You have informed the other side?
Yes, my lord.
Okay. It's legally unconscious for the petitioner, respondent submits that, Mr. Sriram Das, this petition also for reliance is, not this for his, suffering from, he's suffering from,
That's
he has made with an
illness.
So therefore, he seeks 1 week, accommodation. BC matter of.
Let's one more request, my lords.
Yes.
Today, post lunch, your lordship may kindly accommodate me. I have some personal difficulty.
Yes, definitely. Yes.
I will be grateful.
Post lunch, whatever is there, Mr. Riju is. No problem.
Grateful. Is it Juma? No. The parent teachers meeting of my child.
Yeah, definitely. That's very important. You must know.
I am grateful.
Yes.
May I please, Your Lordship?
Yeah.
Your Lordship, here in this case, the appellant is sentenced to undergo a rigorous imprisonment of 2 years for the commission of offense 13(1)(c).
Press one.
My lords, my lords.
Okay. Yes, tell me.
Your Lordship, under section 13(1)(c) of the PC Act, to pay a fine of rupees 5,000
Yes.
and in default to undergo RI for further period of 2 months and rigorous imprisonment for a period of 1 year for commission of offense under section 409 of IPC, my lords.
Yes.
My lords, and to pay a fine of rupees 2,000, my lords.
Why should this court give indulgence?
My lords, it's
Yes, tell me. Why? Under what provision?
under section 389.
389. Have you read it?
My lords, not in full, but
Huh?
I have not read it in full, my lords, but
You should have read the full to get full relief. Otherwise, you will get half of it. I don't. See, the penalty, the fine, relation of fine and state, grant bail, everything.
my lords, oblige me.
My presence may kindly be noted, my lord,
Yes. Mr. Mr.
and free copy be given. Free
Give a
copy.
My lords.
Yeah.
Prayer lords.
Two.
Free
Sentence.
copy of the order.
Yes.
Yes, sir. Sentence.
Sentence for 4 years and 10,000 fine.
Any period undergone?
Yes.
How much?
He must use that number of days I don't know, remember, but he was
During trial.
during trial. The co-accused has already been that
Same amount.
same
Admit. Okay.
689 of 2020.
कोई कितना लिखी दो
618. It was admitted on
कोई accused has already
15/7.
on bail. While allowed
689.
689. Criminal appeal number 689.
689.
Yes.
689.
And tag with 689.
Yes.
ठीक है. Okay, Mr. Sanjay.
Urgent copy.
Yes.
689 of 2024. Your lordship have admitted on 15/7.
Yes. That time.
LCR has been called for in that matter, my lord.
LCR in that in the earlier matter, LCR has already been called, so it will be tagged the same LCR.
Yes, my lord.
Item 3.
May I please, yours?
Yes.
The petitioner is in substance. Filed this revision petition against the order passed by the court below in a discharge petition, my lord. The petitioner is the wife of the accused, and in the FIR has been filed after due investigation. There, the petitioner has not been added and accused, and when the charge sheet was filed, she has been added and accused only by stating that. I'm taking your lordship to the last page.
Yeah.
47.
40.
47.
Okay.
Srimati Suprit Dalavera, wife of accused, assisted Sri Dalavera in acquiring the assets as such.
Where are you reading exactly?
47, my lord, or
40.
from the above calculations. Last page, 47.
Yes, 40. Yes.
From the above calculations, accused Manoj Kumar Vera is found next paragraph, next line, my lords. Srimati Supriti Dalavera, wife of accused, assisted Sri Dalavera in acquiring the assets, etc. They both are liable for offense punishable under section 13(2).
109.
109 only. That there is no other statement to show that in the charge sheet.
Have you?
I have filed a petition before the court below to discharge the
Have you put forth separate defense?
Yes,
yes.
page 7.
7. Up
Yes.
to
Page 7, my lords, paragraph
7
F,
of
my
the
lords.
petition.
Yes, ma'am.
If you have put forth the
The
separate
Lord and
defense,
Lord Court of failed to appreciate the petition has its own source of income and sees filing income tax returns
then
in
that has
clause.
to be accepted.
Yes, madam.
If there are cases where the wife says that I don't have any income,
No.
And
Here
everything-
that is not the case.
Then-
I have gone through your
then
lordship.
I have passed a judgment.
I have gone through your lordship judgment.
That's
I have
the
conscious about that. For that reason,
That's
I am
the
not.
distinction.
I take notice, my lords.
We
my
will
lord.
dispose it up. Why not?
Yes, ma'am.
My learned friend may take notice and
No, there is no point because eventually you know what is going to happen. I will keep every contention of yours open to be argued at the appropriate.
yes, madam. I
I
Your
feel,
lordship.
yes,
Lord,
Madam,
pass
may-
notes.
may I pray?
yes.
Let
And
a
what else you need, you tell me.
my lord, because the petition,
I'll give you.
the petition which I have gone through the petition, it is not as per the what I have stated in the criminal division petition. Your lordship may give in liberty to file a fresh petition that may be disposed of that much.
Unnecessary. You have a separate defense.
My lord, I have the document to show that
You
this is
can't
not
release
mentioned.
all those things. Your
It
department.
has been seized by them. It has been seized by them,
Part
not at the part.
part
they have
of the
seized.
charge
But
sheet.
see,
part of
I'll
the-
tell you one thing. Your discharge application is rejected,
Yes, madam.
but still you have charge has not yet been.
No.
Still you have a option to argue the matter at this stage.
Well, I may argue.
I'll observe that and.
No, that is argue is that
You argue all this point. It is open. The same thing. Instead of moving a separate application, you argue all these points.
no, my lord, because the points which I have raised in this petition that has not been taken by the advocate in the court below.
That
That
can't be. You move an application wrong, right? Whatever it is.
No,
rejected.
for that reason I apologize before your lordship and
No, that can't be.
want to take liberty to file a fresh
You
petition.
can't be given repeated liberty
No,
for moving
for
same
the-
application.
for
before
the
trial
fa-
court to
For the
prolong it.
first time I am praying, my lord, for that.
Therefore, I'm giving you that liberty that whatever point contention you have raised before this court,
Reiterate.
all these things are kept open to be
Reiterate.
argued at the time of framing of charges.
Reiterate.
Yes, madam.
You get an option of.
Yes, madam.
Very good. Right down.
My lord, in fact, my learned friends, I appreciate, my lord, he has fairly stated, after going to your lordship judgment,
That's right.
he early fairly stated that I
That-
have to separate income.
That is
No,
the way you
no.
have to conduct.
It is the fact of the case.
No, no,
I should have taken.
I appreciate your fair
I
submission.
never submit any wrong before the court and taken order of thereafter.
A brief comes and goes,
Yes, madam.
but you have to stay.
And he has stated.
I have to stay here.
Never
He
had
has
to do
stated
that.
that thing after going to your lordship judgment.
After telling a wrong thing, I cannot show my face before
I
my
appreciate.
friends also.
I appreciate. In this petition, petitioner has challenged the order dated 20th July 2023, passed by the Special Judge Vigilance Baripada in VGR number 47 of 2012, whereby the application moved by the petitioner for discharge under section 239 CRPC has been rejected. Has been rejected. Mr. Biswal, learned counsel for the petitioner, fairly submits that he has taken various points in the present petition. However, the same has not been canvassed before the court below, while pressing the application under section 239 CRPC. Therefore, he submits that he should get an opportunity to urge all these points before the trial court, and the trial court should consider the point on its own merit. Since the application under section 239 CRPC has already been rejected, however, the charge has not yet been framed. The petitioner has all the liberty to raise all the contention as has been raised in this present petition before the court below at the time of framing up charges. If such pleas are taken before the court below, I believe the trial court would consider the same on its own merit and consider on its own merit. With this observation, the petition is disposed. You argue all these points.
Yes.
Yes.
Item 4.
Item 4, may I please your lordship?
Yes.
In this revision, my lord, the petitioner was challenging the order of rejection of a criminal miscase.
You use the mic. Yes. Challenging what?
In this criminal revision petition, the petitioner was challenging the criminal miscase which was filed under section 457 of CRPC for releasing of the accounts, my lord. The petitioner is the wife of Piyush Kantapani, one Piyush Kantapani, and
You are not the accused. You are
Sorry.
not the accused.
Sorry, my lord.
Are you an accused in the schedule of offense?
I'm submitting.
Yes.
Yes. And the daughter of Dr. Bholanath Dwivedi and Dr. Rajani Rani Dwivedi. The Piyush Kantapani, while working as an additional commissioner, city and GST, was subjected to vigilance raid, and consequently, the FIR was lodged against the Piyush Kantapani, her husband and wife of the in the name of the petitioner, my lord. And we pray for, in the court below, we pray for the release of some account which are mentioned in the FIR at serial number 22 of
These accounts
assets.
belongs to you.
Yes, my lord. Assets movable in serial number 2. Kindly have a grant to that FIR, my lord. It says,
Now, are you an accused in the FIR or not?
yes, my lord. I
That's
am
what I'm
accused.
asking.
Yes, my lord.
You are an accused along with the Piyush Kant.
Yes, my lord.
And what are the offenses?
Offenses, offenses under section 13(2) read with 13(1)(b).
Okay. Who is the government servant?
On the allegation of disproportionate of asset. My lord.
Piyush Kant is the.
Yes, my lord.
How are you related to Piyush Kant?
I am the wife.
Wife.
My lord, kindly have a grant to the page number 24 of my petition. My lord.
Charge sheet has been filed.
Sorry, my lord.
Charge sheet has been filed.
No.
Investigation is still on. How can 440?
Kindly have a grant to the.
Investigation is still on, sir.
Yes,
Let it-
my lord.
Let it be over.
May I submit, my lord?
Huh.
One thing, the kindly have a grant to that to page number 24 of the FIR
24. Okay.
of my petition, my lord.
24 of your petition.
Yes, my lord.
Okay. Yes.
That is the FIR.
Yes.
Serial number 22 contains with the 11 numbers of account. My lord, may got it.
Mm-hmm.
And thereafter, first, these are serial 1, 2, 3, 4, accordingly,
Right.
11. And thereafter,
Are you working anywhere?
sorry, my-
What is your
No.
source of income?
sorry.
What is your source of income?
Oh, because these accounts are opened in the name of my father. These are all belongs to my father.
When it was open? When it was open?
These are
During
all-
the check period?
Yes. And now my father is dead.
That's right. During the check period, these accounts were opened in the name of the father-in-law.
Yes.
Father-in-law.
Father-in-law, yes,
Father-in-law Piyush Kanti,
Piyush
obviously,
Kantapani.
I can
Yes, my lord.
understand that.
Yes,
I have
my
not read it, but whatever you are saying.
yes.
And thereafter, what had happened is the father-in-law died.
Died.
And the accounts
And the
transferred to
accounts are
daughter.
settled in my name.
But you tell me what is the source of your father-in-law?
He is a doctor. He is a doctor, and my mother is also a
So
doctor.
in the investigation, this will be seen. Let
That
the
is
investigation
what-
be over.
Why I am coming to this court.
Mhm.
These are all accounts, the serial number 1 to 8, my lord. These are all open in the name of my father, my bereaved father.
Right.
And though the account number mentioned in serial number 8, 9, 10, and 11,
Right.
these are opened in my name. That is why I am not praying for the account number below, which are open in my name. And I pray.
But it has to be seen whether during that check period it has been done or not. What was your father's income? And all these things required to be gone into in the investigation.
My father
it
is-
can't be released prematurely at this stage.
My father is now dead. Before the FIR was registered or the raid was made, my father is not in the mortal world, my lord. So
That's
how
right. But the allegation
how the
is during
property
that
of a
check
dead
period,
per-
these accounts were opened
Yes.
and you are the father-in-law.
Yes.
So it has to be gone into in the investigation whether the father-in-law has the independent income or not, and all these things has to be
Oh.
gone into.
Obviously, I have already stated to the IO and
Charge sheet has not
why-
been, when the charge, who is appearing? When are you going to file the charge sheet?
In fact, this is.
What I'll do is, I will
Let it place,
dispose it up
Yes.
with a liberty to you to file a fresh application of the charge sheet is filed.
after charge sheet, my
Yes,
lord,
obviously, without charge sheet at this stage, how can I release everything? Investigation is going on. It is premature, basically.
No, in fact,
You're all-
if I understood your case properly, your grievance is pained with two things: release term deposit and gold ornaments. Release term deposits
Yes.
and gold ornaments.
yes, my lord.
How, whether that
Yes.
pertains to the D amount or not is to be.
That is, the investigation is still going on. Let us see. In the investigation, it may so happen that they may say that these are not the relatable account. It is independent of these things.
My lord, I have some proof. May I show some documents, my lord?
Proof, the police will see the proof, not the court at this stage. You have, I'll tell you, he has gone to the court in a premature state.
My lord, I came before this court with a clean hand that those accounts were opened in my father's name and
I understood. Don't repeat it. I understood it.
and
But I'll save your, the observations which are made by the court will not come in your way. And after the charge sheet is filed, you can repeat your application without being influenced by the observation of the court below. At this stage, the application which you are going to move after the charge sheet is filed will be decided on its own merit.
may I submit, my lord, one thing? In so many vigilance cases, the charge sheet was
I will record a statement that the charge sheet will be filed.
Expeditiously,
Expedite.
and I will also
Okay.
personally, my lord, whatever he has submitted, my lord, I'll surprise with the IO that look, these are the if these things are exclusive with
My-
the father-in-law of
That has
the
to be
main
released.
accused.
That has to be released. Why to
I'll
pass?
also,
My lord,
Lordship may
the
dispose it,
FIR
but I'll take her.
may I submit one thing, my
Yes.
lord? My lord, the FIR was registered in 19/10/2022. Till date, FIR was not, charge sheet was not filed.
Therefore, I'll give a direction to expedite. That is in the that is the best relief you can get, and you should and so
And
much is said about all these things.
may I
No
submit
material whatsoever is even produced before the court
May-
from the side of the petitioner to establish the fact that the petitioner had any source of income and all. All
Pardon.
these things you have invited in a very preliminary stage.
pardon to
You should
mention,
not have invited.
pardon to submit another thing, my lord. The entire before the FIR was registered or raid was made, there is a provision of Section 18A in the Prevention of Corruption Act, which was not followed at all during the seizure or attachment made of these accounts or any immovable property, my lord.
Yes. Yes. Anything else?
So at least 18A should be followed in the
All these things will be done after the charge sheet is filed. Wait, the charge sheet is not filed yet, as yet.
In fact, his prayer before the learned trial court at page 38, my lords, on two aspects: gold ornaments, whether that is a claim, bro. I will also talk to the IO
But
that.
see, 2022 the FIR. What is the problem with him is 2022 is the FIR. And
Takes some
the
time.
investigation is going on so slow. And
It's not continuing unabated. Lordship may,
My lord.
and I tell you,
Lordship may utter the words that it should be expedited, and I will also see that. I
and
assure
actually
the
these are
son
the
court.
things which you are asking is not basically the
What?
things which is hampering your day-to-day life.
Correct.
You can wait. Are you agreed? But every day you are using the gold ornament. What? It can be released after.
I wish had there been any urgency contingencies.
There is no contingency as such. So wait, I'm passing an order
I
in
am-
your favor only. Don't worry. I'll do it.
may I submit another thing, my lord. Because of the career of the child, which was constrained to file this petition for me,
When
my
the
lord.
child comes,
Yes, I take that aberments, my lord. Kindly
you
have
worry. The petitioner is the wife of the main principal accused, where the child comes in.
child because of the I am praying for the release of this account, the amount
Once it is released, your DA case against your husband will go or what?
no, my lord. If my lord release the amount, I can file the affidavit in anything goes wrong or anything contrary to.
Array, you don't understand. It can't be done like this. Investigation is still going on. Right now, the petitioner has challenged the order.
My lord, may
dated,
kindly pass over the matter. My senior will come.
No, you have argued better than your senior. I tell you.
No, my lord, kindly
All
pass
you have
over.
touched all the point. If your senior comes, I'll simply dismiss. Take it from me. I'm going to give you relief because you argued. You argued so well. You argued so well. But you want to argue any more point? You tell me. I'll hear it. You argue, no problem. Any other point? The senior can't do better than you.
He has not
Be
left
sure
any
about
stone
it.
unturned. In fact, I have gone through the briefs, my lord. He has not left any stone unturned, my lords.
Yes, he has argued all.
And very persistent
That's all
also.
the point. He is very persistent. Argue, what is the problem? You argue. Any point you want to place, please do that. I'm here to hear you. No problem. Come to the impugn order. Come to the impugn order
Yes, ma'am.
and see the kind of observations made
Yes, ma'am.
will prejudice you if in the future you move an application. So therefore, what I am proposing to do is, I will say that these observations will not come in your way. Once you move a fresh application if the charge sheet is filed. In the charge sheet, many things will be, sorted out. It may so happen the properties which are now seized, they may say that they are not relatable to the check period of the principal accused. It may be taken off. If it is not, then you have a fresh opportunity to raise all the points before the court, immediately charge sheet is filed. And your apprehension that the charge sheet will be delayed, that also I'll try to observe. That I'll record his statement that as expeditiously as possible.
Yes, my lord. I will also talk to the.
What else you want? So I think you covered everything right now. The petitioner has filed the present petitions.
Only my lord, one line, not page 50, my lords. The input note indicates that his grievance before the London Trial Court pertains to only term deposits and gold ornaments.
Whatever is there, he can repeat his appeal.
Yes.
The present petition is filed by the petitioners, by the petitioner assailing the order dated 2/11/2023 passed by the Special Judge Vigilance Cutter, whereby his application under section 457 CRPC for releasing of the gold ornament and the freezed bank account has been turned down. The petitioner is one of the co-accused along with her husband in a disproportionate asset case. The investigation in the present case is still going on. Charge sheet has not yet been filed. Therefore, in my considered opinion, the application under section 457 CRPC filed by the petitioner is premature. The petitioner is given liberty to repeat his application after the charge sheet is filed. Once such application is moved, the trial court shall consider the application on its own merit without being influenced by the observation already made in the impugn order. You are Mr. Mahapatra.
No, my lord. My name is Jyotirmay Barik.
Hey, Mr. Mahapatra is the name. He has argued very well. He has very well argued. Mr. Jyotirmay. Mr. Jyotirmay?
Jyotirmay Barik.
Mr. Jyotirmay Barik submitted that the FIR was registered in the year 2022. The investigation is still going on, and he apprehends that the investigating agency would delay in filing the charge sheet, which will eventually cause prejudice to him, and his application under section 57, 457 CRPC would eventually get delayed. At this, Mr. Das, the Counsel for the Vigilance, submits that he would instruct the investigating agency to make sure that the charge sheet is filed as expeditiously as possible. With this liberty, the petition is disposed.
Hardship matters, vigilance matters knows that it goes for a year together. Expeditious matters, they will be meaning for 1 year and 2 years. In the process, I will be prejudiced because the
That
property,
I have written it, you can,
I will renew the sprayer
Ah.
if it is not filed within 6 months.
yes. At this stage, Mr. Barik further submits. Huh?
Let's-
ये say the-
Lordship,
2022 FIR, you don't
Yes,
file, you
my lord-
take away everything
my lord,
from their
that
house
I-
and
I will be suffering my.
You can't
No,
take
I
it.
agree with his proposition. What I suggest, my lord, he may be provided with the opportunity to renew his prior notes.
That I said,
But fixing a time limits for completion
I'm
of
not fixing, I'm not saying you.
the 6 months.
What I'm saying is, if you can't file it and you, after
Yes,
6 months.
yes, exactly, my lord.
It can't go in eternity, you know, you take away everything from their house.
Making me bankrupt
And-
completely. And then.
Whatever.
Not
See,
bankrupt.
Then what happens is, in the vigilance case, what happens is you come to somebody's house, raid and take up everything. And you put them in their head, you keep on explaining it. It is very difficult. So at least expedite it so that they will not be left
Right.
with grievance.
As expeditious as possible.
As expedite as possible. At this stage, Mr. Barik submit that,
Mr. Mahapatra.
Mr. Mahapatra submits, Mr. Mahapatra.
In the midst.
Along with Mr. Barik, submit that the prolongation of filing of charge sheet is quite often in the vigilance department. So therefore, he apprehends that it may not be filed.
Due to cumbersome procedures,
May not be filed due to the cumbersome procedure.
formalities.
Procedure and formality to be followed by the investigating agency and during the investigation. Therefore, he says that if the charge sheet is not filed within 6 months, his right to revive the application may be reserved. I accede to the request made by Mr. Mahapatra. He may, the petitioner may revive his application under section 457 CRPC in the event the charge sheet is not filed within 6 months. Hence,
If it is not filed within a reasonable time, lords.
within 6
Reasonable
months,
time
you
of-
file. See, I'm not asking you to file.
Take it.
If you don't file, he has the right to.
Take it.
And be sure about it. You at least that pressure would be there. They'll file it.
Some amount of pressure will be put upon that so that you can.
Pressure, but the cumbersome procedures, it's not practical
Correct.
possible.
That means simultaneously you should see the interest of the party also.
Gold ornaments and things deposit, I understand.
Enough ornament,
And
let us
what
forget about
happened,
that.
they will move another application within, after 6 months, that will be rejected, again they'll come, issue notice and keep on.
Mr. Mahapatra is a seasoned councilman, he understands.
Question of
but-
sitting councillor not. Thing is that 2 part. Ornament, all right, we know that yes, you keep it there. The father's property, you are keeping it there in spite of the judgment of Subhadrama and all these things. And these should be released to us.
But the father
is
has opened the account during the check period.
Well,
During the check period of the principal accused, the accounts were opened.
No,
That's what he said.
no. That was much prior to that. Much prior to that.
Much prior to that.
Before his death.
But,
Before his death, but within that check period of.
No,
the-
my lord.
that all, that is,
That was long.
That has to be gone into by the.
that is
Let them go
verified.
through. There is no problem. Let them go through. They may also consider that. Subhadrama also, they can deal with that. They can pass that order also. They can release this
It
amount.
may so happen that they may release it
They
also
may release also.
during investigation.
It's not matters, may record it, that is not because of during that period.
I
that
will
period.
not record anything to prejudice the
They
investigation.
say,
It is
they-
going on, I can't do anything. But on merit, I can't say because it will prejudice the investigation. Let the investigation.
I don't,
will be a
I'm
balance.
conscious of my position, matters. Fact means I just weigh the, the prejudice caused to the party, simultaneously they are.
Yes. He's suggesting something.
Yeah, no, in fairness, saying correctly, my lords, that delay is not because of the latches on the part of the investigation. Sunni, in a DA case,
there is-
each and every claims has to be verified, examined, depend on other agencies.
No,
6
no.
months is a huge time. Huge time.
But it's a good time for him to reiterate, isn't it? It's a good time to reiterate their claims.
Reiterate.
Same thing, same petition.
Same
Same
thing.
petition.
He
That
will-
is
he-
what,
he will
that
do
is
it.
what I requested, my lords.
Yes, yes. Thank you.
In fact, once we are depending on other quarters, we are sending letters, they have to respond, and then again it has to be evaluated. That is the reason of delay.
Once somebody approach the court, once somebody approach the court, we have to make sure that at least the investigating agencies are put to guard.
Yes, ma'am.
At least they should.
Yes.
But it is
That is-
So therefore, it's a
2022.
balancing order. I'm not giving a direction.
Yes, ma'am.
If
But
you
it is
don't
two-
want to do, he has a right to move application, let him move that.
It is 2022. Now
But
I
your
will-
application is very premature. You should not have gone now.
Wait, my lords, that my lords. The urgency, because of the urgency.
What old government agency?
Ornament is not material, my lords. Material is that amount it released my son really medical comments. That is what I am to deposit the money. That is what I have insisted there.
Anyway, we'll see.
And that to the money is of his grandfather.
Okay.
May I please, Your Lordship? My lord, I am in Bhachor mode. May I audible, my lord?
Yes, yes.
Well, my lord, the case is under section 20B2C of the NDPS Act, my lord. And he is in custody since 11th November 2023. And
11th
allegation in
November.
11th November,
11/11/2023 custody.
my lord, 11/11/2023. Allegation against the present petitioner is that, my lord, on the date of occurrence, my lord, 3 persons standing in front of the house of the present petitioner, my lord. 2 persons apprehended at the spot, and 62 numbers of packet, that is 516 kg, has been seized from the in front of the house of the present petitioner, my lord. Thereafter, the present petitioner absconded from the spot, and basing upon the co-accused statement, the present petitioner voluntarily surrendered before the learned court below, my lord. And
Where is the chemical examination report?
my lord, till yet the chemical examination report has not been submitted, Your Lordship.
See, on 6/3/2024,
My lord.
I have disposed of your bail application on that ground only. Just see para 2.
My lord, DLAPL,
Dated 11/1/2024. In the charge sheet, chemical analysis report has not yet been filed. Therefore, he seeks leave of.
no,
this
my lord,
court.
that is other accused, my lord, who apprehended at the spot, he Harendra Yadav, my lord.
Bail 4074/2024.
Hmm.
Fixed it today, my
DLAPL
lord.
599 of 2024, that is Harendra Yadav.
BLAPL 4074/2024.
It was listed today.
Fixed to today. So that has not been listed. I pray, my lord, the matter may be listed along with that case, my lord.
Okay.
Tuesday, ma'am.
What is it?
BLAPL 4074/2024.
Mr. Raghunath, Learned Counsel for the state submits that the co-accused bail application number,
BLAPL
BLAPL number
4074
4074.
2024.
May also be listed along with the present petition. List the present petition along with so and so. The next weekend. Yes. Next.
Kind of date may be fixed, Your Lordship.
Yeah, date is quick.
Oblige, Your Lordship.
Item 6.
Next week, no, I'll go.
May I please, minute. So cancellation of bail, minute, it was registered minute day before yesterday. So directed to minute give payment of rupees 5 lakhs, which has given undertaking that in the order dated minute 13/3/24 at page 11, minute annex 1.
The direction was to pay 5 lakhs.
Undertaking the amount he has taken, minute he has given. And can
Where is that undertaking?
minute can you down to minute the page 12, minute
Sure.
paragraph 4, annex 1, minute. And counsel for the petition on instruction submit that the petition ready and willing to pay total amount taken by him in lieu of the selling of a piece of land.
Yes.
Let's say I am in a Sisyphean dilemma. How to sell the land and who to sell the land? I totally agree.
You should have thought about when.
No,
making
let's see,
statement.
where is the difficulty? Let me explain to the honorable court. my humble submission is that, yes, admittedly, we have received 5,50,000 and we are ready to return it. But people are abreast that there is a dispute going on. Whoever we are approaching to sell the land to, he is disagreeing. Why? Because they know that there is an encumbrance. This man hoisted a false case, Millard. The FIR was made against 3 accused persons. The son of the petitioner who has been released on bail, that is also, his name was also there. He was totally discharged. And the charge sheet found that there are the omnibus charges they made in the FIR. It got curtailed and only 3 or 4 sections remained. Now a 420 section remains there, which is going on in the trial. Now, if I return the amount to the other party, then what happens? That case, in fact, chases me. If I am ready to sell the land even to him, let him pay the market value, let both the parties come and attend this honorable court and let him pay the market value. I am ready to sell the land. We have not receded. We have not receded from the agreement we made. He receded because he didn't pay the remaining amount. Now we are ready to sell it. Unless we sell it, how can we get the amount? And what would happen to us? Because we suffered inside the custody for 3 months. Who would compensate for that? Now, this man, if he allows us to sell the land to him, then we are ready. Let him pay the
land is with you.
Yes,
You
with
entered
me.
into a
With me, but who to sell to?
Taken 5.5 lakh. And thereafter, these stories will not cut any eyes. Why have you executed an agreement and taken the money? If you have taken the money, if you don't want to give the land, give the money.
No. We are ready to give the land, but he should pay the remaining money, na?
Why should I go
He
for
should
that?
pay the
You have
remaining
taken
money,
the-
Lordship. My humble submission is, I took 5,50,000.
Consideration amount is 17,50,000.
17 lakh. Now the market value is different because again another agreement was made where it was decided that the market value then was 18,50,000. Now that date has already passed. Now the market value is different.
In this proceeding, I am not going to decide what is the market value and all.
That-
Now
that-
the fact remains that you got the bail with an undertaking that the money which you have taken,
Yes.
you will refund it.
Yes. We are totally
So
ready to.
you may have 1,001 problem.
Let's
That
say
time
then-
you should have contemplated all these things.
Then let's say two very simple things.
I can only accommodate you to the extent that if you need some installment and all, I can accommodate to that extent. But I can't vary the order. Once you took the when you are in the custody, you want to make every kind of concession.
Lordship,
So that you come out. Once you come out, then you play the game.
No. I'm not playing the game here. I'm totally with a clean hand. With a clean hand, I'm approaching the court. I am saying that either you pay the remaining amount and I sell the land to you.
So this is again, I am deciding a specific performance.
No, Millard, my
Under
audience.
section 20, I will give it direction.
Millard, Millard, yes.
I have to invoke section 20 of specific.
Millard, the order of your lordship is paramount. I understand that, and it is the discretion of your honorable court.
When are you going to
lordship?
give? When are you going to give? How much you will give? To begin with, you tell me.
Yes,
Forget about it.
Lordship, we will give.
When? Next week?
No, lordship, let the other party.
1 week thereafter.
One
how much
thing-
you come with? To
No,
show your balance?
one prayer, lordship, one prayer. Let the other party come to this court and let him ensure that he would withdraw the charges against us of that 420 section. Because if I pay him, now again he would
See, I'll tell you one thing.
Yes.
You had considered that you will pay. Your statement is recorded. Now you are imposing condition on him that unless he does it, I will not give.
That
Then go
420
to the-
element is totally false. Millard.
Then go to the custody. Let the bail application, it may be decided on its own merit.
Yes.
That's the only way out, I can tell. Because the bail was granted only on the basis of this concession. If you are not willing to comply the condition,
Millard, one thing.
try to appreciate. If you are not willing to apply the
Also,
condition,
kindly
then
note
your
page
bail
37.
application has to be decided on its own merit.
On page 37.
You also kindly see
He has given an undertaking before the court
court below. Page 37.
High Court of
I know,
Orissa
I have-
You are playing hide and seek with the courts, Millard.
You can't,
let's-
Undertaking before this court, undertaking before the trial court. Now
High
he's saying
court
other
proceedings
conditions.
and trial court proceeding, you can't take everything
Lordship,
granted.
unless I sell the land, where from I'll get the money?
I don't know, sir, whether you sell or you borrow money or whatever. I don't know. When you made the statement that time, you should have known What is the complication?
Then Lordship may kindly give me a scope for installments.
That's what I'm suggesting. I know you may have a financial problem. That is the reason you might not be in a
Extension of
position
time
to
and
pay.
installments.
But to show the bona fide, come with
Exactly,
some
yes.
money so that it is not, I am not going to interfere. I will rather persuade him, take this money and
Close the case, my lord.
Close.
Exactly.
that is the idea.
Yes, let him then
If
ensure.
you give 5 lakhs,
50,
50,000
yes.
and he
I'll
file
close the case,
482
Milord.
petition and quash everything and go home.
Yes, my lord. There's no problem.
Why are you into this all these things?
All the charges would be withdrawn.
Obviously, he'll file
Discharge.
he is interested in his money. You pay him back and he will
Then let that reflect in the order of your Lordship.
You show me the color of the note. You show me the color of the note. Thereafter, you will say that since he has said he will file a 482, let it be quashed, then I will pay. Because your client is not fair.
As your Lordship.
Come
thinks.
with the money,
Yes, sir.
I'll hold it
Yes,
and he'll go and file a 482, then I'll release.
Yes, my lord.
Come with the money.
Lordship, as your Lordship wishes.
Come with a draft of 5.5 lakh and I hold it in my court. I'll ask him to file a 482.
Yes,
petition.
Lord.
Get it quashed, then I'll release.
Yes, sir. No problem.
Your case is over, your bail
Everything
is
is
over,
over.
your everything is over.
Everything is
And if
Your
Lordship,
specific performance and everything.
over.
Lordship, if Lordship gives scope to for installments, then when he would pay the total installment, Lordship would give that scope to us.
Installment, then
Extend-
separate to how will he file.
Exactly, my lord. Leave time, my
Now,
lord, will
this money, borrow money and see.
Then Lordship,
there are problems.
it may come in with an adjournment in a short date, so that I can take instruction whether he is ready to
Next Friday.
next Friday.
And next Friday, otherwise I'll cancel it.
Yes,
Take
yes.
it from me.
Yes.
You
yes.
come with.
No, I'll be honest to my.
Come to show bona fide, come with some money.
Yes.
So I'll hold it. Otherwise, I'm going to
Yes, my lord.
straight away recall the order, go to the custody and move application on merit, it will be considered.
Lordship.
This much
Yes,
liberty I'm giving. And you borrow money, pay.
very easy to
because
take money,
You have
but
taken
very
the money,
difficult to
not that
collect.
you have not taken the money.
Yes.
You admit that you have taken the money.
If he comes with some less
And
amount,
if you have
again he
got
No, no, amount was taken.
jail for 1 month or whatever, it is because of your problem. You are adamant not to pay the money. If you would have paid the money, you would not
I
have.
would not have come, my lord. I would not have come.
no.
Your kind is not fair. You have taken the money, if you would have paid,
I would
this
have
FIR
come.
would not have been there.
Exactly, my lord.
Ultimately, you will have to pay 1 month, you have already unnecessary went to the jail. And if you don't pay, then you will have to suffer for years together. Keep on facing trial and all. Come with, next Friday, you come with some amount of, get some draft, 2-3 lakhs, whatever. And the remaining amount, I'll give you some time.
Yes.
Yes,
If
yes.
you don't come with any money, then no question of giving.
Lordship.
Shall I record it?
Yes,
Huh?
yes, Lordship.
The counsel for the opposite party submits that the
Open about
undertaking he had given to the court to pay the disputed amount to the petitioner shall be complied with, but he needs some installments. He further submits that once the said amount is paid, the entire case should be put to rest. Rest. The counsel for the petitioner submits that once the amount is paid, then he will persuade his client to move appropriate petition before this court for seeking quashing of the entire
Yes, sir.
proceeding. That view of the matter is adjourned to next Friday.
Highly request.
I have recorded that also. You once pay, he will move an application under 482 and quash.
Yes, sir.
Very kind of Lordship.
Come with 2-3 lakh rupees, whatever you have,
Yes, yes. Lordship.
give it, and the remaining
So the
amount,
bona fide.
what we will say is the remaining amount, you will file a 482 petition. At the time of filing of 482 to disposal of the 482 petition, the remaining amount will be paid there.
Lordship.
Yes, ma'am.
Then on that day you pay the amount, 482 is allowed,
Cost
you are
and it
free
is
and he
free.
is also.
Obliged.
Yes.
Item 7.
Item 7, Lordship, your Lordship has disposed of this matter on 2/1/2024.
Sorry?
Lordship, this matter has been disposed of on 2/1/2024.
Yes.
But the learned court below has
With an observation that direct the court below to conclude the trial as soon as possible within a period of 6 months from today.
Yes. What happened then?
Lordship, it has been disposed of.
Court मागचे extension.
The court.
The court has
PGM कम नहीं extension.
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 By the order dated
2124.
dated 21/1/2024, this court has directed the court below to conclude the trial, huh?
Yes, Your Lordship. Within a period of 6 months.
To conclude the trial within a period of as early as possible, preferably within a period of 6 months. 6 months. The learned, who has written this letter? Huh? The learned CM come assistant station says, Bhubaneswar. By the letter dated 22/7/2024, seeks an extension for the time for disposal of the trial. For the reasons stated in the letter, the time for conclusion of the trial is extended. Within extended for another how much time? No, it cannot be done evidence. Trying hard to ensure that the attendance within a short period. Who is not coming? Apart from that, other 4 witnesses are yet to be examined. In such circumstances, notice some more time. How much time? The another 4 witnesses are yet to be examined. Thereafter, accused statement. Thereafter,
Another 6 months.
Lordship, in this case, all the witnesses have been turned hostile.
that's right, no problem, but it has to be concluded. That apart, other 4 witnesses are yet to be examined.
Yes, Your Lordship. Lordship.
In spite of repeated summons, they are not turning up. For further period of 6 months. Further period of 6 months.
Obliged.
Item 8.
And here in this case, 2 cases are disposed of by Your Lordship. That is one CRLMC 1409 and another is 1128, where the ST case, the announcement of judgment of ST case was stayed and the 1CC case is to be tried and both the cases will be disposed of analogously. Now the stage of the 1CC case is charge has not yet been framed by law and it is posted to 12th of September. My only prayer, my lord, that 1CC case be targeted so that both the cases will be disposed of.
One case is targeted, it is tagged, then obviously.
And he has filed a IA, the copy of which was given on demand just around 10 o'clock. So he makes some statements which I am not having knowledge. Your Lordship was pleased to say that it has to be disposed of together, and Your Lordship has never hindered anything. So he wants a direction in the disposed of case that it should be. Your Lordship may kindly see the modification.
Both the matters are tagged now. In one matter, target is fixed.
Your Lordship may kindly see the.
What I gather, he wants Your Lordship to regulate how the trial court will proceed.
No, that
Not
see,
to
no doubt.
regulate, my lord.
Now,
Your
the
Lordship may-
stage of the trial in both the cases are different.
Different.
I have written, right?
Yes, my lord.
Therefore, the
Now
clubbing
the-
both the cases
now the
may
stage
slow
of
down
the-
the
my lord,
ongoing investigation. So on, so
At
on,
the
which is
stage
at
of
an
the SD case,
advanced stage.
ST case is
Therefore,
that
it would be appropriate that both the cases are finally decided analogously without impeding the pace of the trial in both the cases. Okay. Accordingly, the application under section so and so is moved by the petitioner are liable to be allowed, and ICC cases pending in court of so and so Nimapada is directed to transfer to the learned assistant station in Nimapada to dispose of the same finally with the ST case. What is wrong?
It's clear, ma'am.
That is very clear.
I am not disputing that the order is not clear. My only prayer is that ST case ta final stage re अछि केवल argument of judgment.
No, that I have taken care
My
of.
lord, ଆଉ 1cc case ଟା ବର୍ତ୍ତମାନ charge
No.
frame ହେଇନି ତେଣୁ 1cc case ଟା ଟିକେ target
You have to tell that because I have given the target that both the cases should go together, and you have
It will
to
be disposed of.
persuade that court. I can't regulate. Mr. Mishra is correct. I can't regulate here proceeding. I don't know what circumstances.
because my lord,
How many
in
witnesses?
the, my lord, in the meantime, the petitioners, they have dashed the truck with the informant in the ST case and another.
If you can speak on the mic, I can hear it. I'm not able to hear it also.
Hey, listen, have you told all this thing to the trial court?
My lord,
Have you told? Yes or no?
my lord, that no petition was filed before the trial court, but
Then counsel for the petitioner seeks to withdraw this petition to approve the court below and highlight his grievances. If such application is moved, same shall be considered on its own merit. With this observation, petition is disposed. Yes. Next.
Item 9.
My
Move application and tell that court that this problem is there. Whatever.
my lord, the case connected case that is 1409, which is not on board, my lord. I have also filed another IA. If your lordship called that matter and disposed of both the cases.
When
today.
that is okay.
That has not been
Call it
listed.
for tomorrow, same order. Huh? Yes.
1409 of 2022.
Yes. Tomorrow it will be listed the same order.
in fact, both were disposed of together.
Huh?
Called it today and disposed of.
Special notice to lage kar do. ठीक.
CRLMC 1409 of
Both the
2022.
order, both the applications disposed. Yes.
Item 9.
Item 9, my lord, on 26/6, your lordship directed my learned friend's son to prepare the paper book at his own cost. On 26/6, your lordship may kindly have a glance to the order dated 26/6.
26/6/2024 only says that as requested lease the matter.
Your lordship, the son of my learned friend submitted to prepare the paper book at their own cost. At their own cost.
You may be remembering, I don't remember, and Mr. Panda is laughing. What to do?
His son was appearing on that day, my lord. My learned friend's son.
Anyway, what?
My associate was appearing, Mr.
Yes, yes.
When he appears in court, he is not my son.
Maybe.
Yes, correct.
He submitted and he wanted to prepare the paper book at his own cost.
Yes, yes. Now
Let
I
him-
think he might have prepared it by now. Not prepared.
We told the party Millard. He heard and has gone home. If he
What to
doesn't,
do? What to do now?
let's let the office prepare the paper book, we'll pay the cost.
Let the office prepare.
You tell your junior take pen drive. She can take and take the printout and let us hear the matter. She will do it. She has been doing it. Take in the pen drive. You take it. If you have a good case on merit, argue and finish it up.
I have a good case on
Then
it.
argue it. Fix you get a pen drive. Take the entire LCR and whatever is there, and take out a printout and give it to him. Prepare and brief him. When do you want, sir? You tell me.
Lordship, give me some time.
Yes.
By the end of August.
What is your name, madam?
Mehta. Ayushi.
Ayushi.
Ayushi Mehta.
Ayushi
Mehta.
Mehta. Learned counsel, learned briefing counsel to Mr. Devasis Panda is given liberty to take the soft copy of the entire document from the court and prepare and LCR, soft copy of LCR, and prepare the paperwork and supply the same to the counsel for the Mr. Sanjay Das. Mr. Sanjay Das. Lease the matter. You tell me.
First week of September.
Why are you going September? You talk about
August.
Yes, September. There are so many year-old matters, my lord. Your lordship.
15th, I think you will be independent. After 15th, you will be independent. After 15th, immediately.
Hey, Lordship, fix it in the last week.
So, but at your level, you can, try and we'll finish it up. This is very old matters. Okay.
Week beginning 27th, any day, Your Lordship.
Yes, give it.
I may be supplied with the copies, my lord.
I have given that direction. She will prepare. IUC
Okay.
will prepare and give a copy to you as well as Mr. Ponda. Yes.
May I pray that your lordship may kindly adjourn item 19 to the next Friday.
Wait,
I have
let 19 come. Let 19 come. I don't know who is it.
Hey, he is ill, my lord.
I have
Okay, you are
already,
not.
That is ill.
Okay,
I have
19. You
I
are
have
released. I will adjourn it and intimate the date. He's not
I have
here.
already told Mr. Dhal he is
It's
agreed.
all right. I'll accommodate you. Please go. Don't worry.
Okay. Obliged.
And this is only 19 one matter. Any other
19,
matter you have?
19 is a parted matter, my lord. Your lordship has had in part.
Okay. 19, huh? He's not good. Yes.
May it please your lordship. Here, my lord. I have filed this petition against the rejection of my petition under section 457 CRPC to release
I think limitation is there. No?
limitation.
I think application he has filed for.
I file an IA, madam. Because what has happened, my lord, you'll kindly have a glance to the page 24 of the brief, my lord.
24. Yes.
Learned Court below heard the matter on 15/7/2022 and passed the order on 22/8/2023.
15/7/2022.
Paragraph 2.
Yes.
Paragraph 2.
Pass the order.
On 22/8/2023, a year after.
So, you are agreed by that?
Yes, my lord. And
you want that matter to be heard once again?
1 second. Because this is after 1 year, he has passed
He
there.
has passed the order after 1 year. So, whatever he has argued, the court might have forgotten also. This is human, of course. Let it be set aside and let the application be heard once again. Fair enough. Fair enough. Because of the pressure of the work, the court might have forgotten also. And the Supreme Court says, Anil Rai says 3 months.
At the same time,
Anil Rai says that 3 months, if it is not pronounced and it has to be reheard. Exactly, he is asking that.
not sure at the same time, this case we disposed.
This case, I will dispose it up, setting aside and relegating.
But that IA also be disposable.
Everything.
Merges with that.
IA condemnation release. The trial court delayed, he has a grievance. And now he has delayed, you have a grievance. Right. The petitioner has challenged the order dated 22/8/2023, passed by the Latent Special Judge Vigilance, Sambalpur, in criminal meets application number 6 of 2022, whereby his application under section 457 CRPC has been turned down. And level counsel for the petitioner at the outset submits that on merit he will not address this court. He is only he is confined his grievance only to the fact that the application was heard on 15/7/2022. However, the judgment was passed on after more than 1 year. That is on 22/8/2023. Therefore, he submits that the application requires reconsideration in view of the delayed disposal by the court below. Next court. The Honorable Supreme Court in the matter of Anil Rai versus also has settled the law in this respect that every court should dispose of the application public matters pending before dispose of matter within 3 months from the date of judgment trigger Otherwise, the application of the matter should be answered before for relying upon the state judgment, Mr. So for the petition service that the matter needs to be reheard. I'm completely in agreement with the counsel for the petitioner. Therefore, the order, impugn order 22/8/2023, passed by so is set aside, and set aside, and the application under section 457 CRPG is restored to the file to be heard afresh, and disposed of. The observation made by the trial court in the impugn order shall not influence the fresh disposal of the application. This observation petition.
May I have one thing, madam? Let a time limit be fixed. It is a
No.
interim application. It is an interim. application.
Why are you so apprehensive? On the same day he'll dismiss it. Don't worry.
Again, I have to come.
The same day he'll dismiss it, will come back. Yes.
There is a delay of 24 days in filing this application.
Yes. What is this matter?
My lord, the petitioner is challenging the rejection of discharge application. At present, my lord, there is 24 days delay in filing the application.
Forget about delay. We'll come to the matter.
My lord, the petitioner challenging the rejection of the discharge application on the ground, first ground is the petitioner is not a public servant in view of section 2(c)(ix) of Prevention of Corruption Act. My lord, the petitioner was working as a chief executive officer of the Urban Cooperative Bank.
Yes.
Urban Cooperative Bank, kindly have a glance to section 2(c)(ix) of PC Act.
Yes, 2(c)(ix).
Any person who is the president, secretary, or other office bearer of a registered cooperative society engaged in agriculture, industry, trade, or banking, receiving or having received any financial aid from the central government or state government or from any corporation established by or under a central, provincial, or state act, or any authority or body owned or controlled or aided by government or government company as defined in section 617 of Companies Act. Well, the Urban Cooperative Bank has never received any fund, any sanction from the state government or central government. Can I have a glance to
State government and central government and
Yes.
instrumentality of the state also.
My lord. Can I have a glance to
Who is your sponsored bank?
it is a own finance, the member of the society. They finance and they.
I think your sponsored bank is State Bank of India.
No, my lord.
Huh?
No, I'm pleased. The audit report and the opinion of Justice A.S. Naidu, who I am citing from the record.
Opinion?
Of Justice A.S. Naidu. In this case.
The opinions are not to be used like this.
My lord, that is in the record.
Don't even use these opinions.
My lord, I am placing the.
First you take out the opinion from the record. Take out the opinion. This is very unfair.
And let my Lord Fred also verify.
See, a former honorable judge.
My lord, he has
is
given
giving a personal opinion. You can't put that as a record
bank.
to influence a court.
My lord, to the bank.
Whatever. See, opinions are not. See, therefore, in the opinion it might be written, not to be used.
No, man. Nothing has been.
But
that
is understood. That's
my lord,
understood. Sir is standing behind, sitting behind. Ask him.
My lord, kindly have.
See, then any retired honorable judge will not give opinion if those things are.
My lord, I am omitting.
Suppose I am deciding a case. You get a former Chief Justice of India's opinion. Put it in record.
I am omitting
then
that.
What is your indication? You are.
My lord, I am omitting that opinion. I am placing
Take off the record.
My lord.
I'll release it to Monday, Tuesday. Take it off. That's not fair.
My lord, today.
Whatever opinion a honorable judge,
I'm
former
omitting-
honorable judge.
I'm omitting, my lord.
don't make that.
At present, I'm omitting, I'm placing on the merit, excluding that.
Yes, yes.
Page 111, Annexure 4.
What, see,
That
this
is
is
the-
High Court, this is High Court, I'll tell you, this
My
is
lord.
High Court, no problem.
My lord.
What a poor magistrate will do,
My lord.
if this kind of opinions are placed as a record, he's bound to be influenced. Wrong, right, whatever.
My lord,
On the back of his mind, he will think his judicial acumen to appreciate a particular thing is completely restricted on because of the opinion given by a senior person.
My lord, I'm
It
omitting.
is the High Court, is a different thing.
I'm placing from the audit report.
He will be he will think that must be correct. Maybe wrong or whatever, but his judicial appreciation is completely restricted there the moment the opinion comes in front of him.
Well,
So that's the idea of not using a opinion given by the honorable retired judges of any court in the court of law.
well,
Yes.
page 111. That is
100?
the audit, 111.
111.
That is the audit report.
Yes.
My lord. 2.
Annexure.
Annexure 4.
4.
Page 111.
Yes.
2. Share capital.
Yes.
The paid up share capital of the bank stands so and so as on 31st 3/2009 as against amount so and so of the previous year. Neither the state government nor central government has contributed any amount towards share capital of the bank since its inception.
Okay. Yes.
That
There is growth at 12.1, all these things are not done. Yes.
my lord.
Yes.
My lord, can I have glance to Article 243 ZI of Constitution of India. That is in respect of the cooperative society. 243 ZI.
Yes. 2 for the Jedi.
My lord.
Yes.
Incorporation of cooperative societies. Chapter cooperative society. Right?
Yes.
Incorporation of the cooperative societies, subject to the provision of this part, the legislature of a state may, by law, make provision with respect to incorporation, regulation, and winding of cooperative society based on the principle of voluntary formation, democratic member control. This is a society controlled
run by the boards. Board
run
of
by the
directors.
So state government
Member economy participated in the autonomous function.
My lord. Here, if state government or central government or any such organization has any contribution, financial contribution, then they have a control over this society. But here, from the record, from the audit report, it reveals that there was, from its inception, there was no.
What happened in your case?
In my case, the allegation is the bank finance to a loanee, he became default and a affair was registered. Allegation in the affair is that the loan was sanctioned, disbursed based on fabricated document, and mortgage deed was executed without ROR.
Yes.
That here, my lord, there is no ROR. The loanee, he availed the property from a state government, from Odisha State Financing Corporation. Lease deed was executed in favor of the loanee. Mortgaging that lease deed.
He taken loan.
He taken loan. That is his title, my lord. Subsequently, when he became default, the property was auction sold and money was refunded to the bank. And another allegation is the valuation was not.
But money is recovered.
My lord, that is in the record. My humble submission is
The long and short of the matter is you have granted loan to someone or using some false paper, whatever, and it was subsequently the property was sold and money was written back.
Madam.
So therefore, 424, 120B, nothing is made.
Madam. And petitioner is also not a government
servant, so 13(1) and all these offences are also not made.
Madam.
That's what you are feeling.
That but
yes, Mr.
In essence, my learned friend's submission is that the accused petitioner for lordship is not a public servant.
This is one. Second is the document which were used for the purpose of availing loan. The loan amount, the property was sold back, collateral property was sold back, and money was refunded back. So there is no loss to the exchequer also.
But other grounds are also there. Sanction back. Here the sanction.
Not the public servant, where is the question of sanction?
Minor.
That is actually.
And another ground, the petitioner is not competent to sanction loan. Only the management, the board will sanction the loan, and board is not made as accused in this case.
Those are different, please. But main point is raising lots. That was before this Honorable Supreme Courts, and the Honorable Supreme Court said, lots, public servants who is held chairman / managing director or executive director. Here the petitioner is the of a private bank. It's a private bank. They say that I'm not giving anything with the government.
There is a difference between a private bank and
a cooperative bank. Yes, private bank operating on. I'm coming to second point. Operating under the license issued by the RBI under the Banking Regulation Act. Can they say that we are operating without the license from the bank? Suni. Bank operating under the license issued by the RBI under the Banking Regulation Act 1949 holds an office and performs public duty so as to attract the definition of public servants for the purpose of BC Act 1988. Your lordship,
what you are saying is once you are regulated under RBI guidelines and all, you are
and my lord, the point
irrespective of the fact that you are cooperative, whatever.
And my lords,
any banking.
This is the judgment of Justice Prafulla Kumar Pant, my lords, and the matter the appellant Central Bureau of Investigation have challenged the judgment. So as a High Court of Jurisdiction, Bombay, whereby criminal revision application file has been dismissed. And in fact, thereafter, the courts below have held that cognizance cannot be taken against the accused, namely Mr. Ramesh Jelly, Chairman, Managing Director, Siddharth Sastry, or that bank name is Global Trust Bank, lords, on the ground that they are not public servants. This was the issue, lords. And lords, and then they briefly stated the prosecution case that Global Trust Bank was incorporated in 1793, lord. The said bank was issued the license dated 6/9/94, under the Banking Regulation Act 949, lords. My learned friend is fair enough saying that this is all bank. It cannot run without the license issued by the banker's bank. The Reserve Bank is the banker's bank, lords. And lords, under that provisions, lord, they are provided with the license to run the banking activities, lords. Now, any person, chairman, is because they stand a different footing than the employees of the bank. Chairman, managing director, executive director, and on the basis of this, probably when the 2018 amendment came in the Prevention Corruption Act, 29C, my learned friends submitted, my lords, there the word was incorporated. 29C, my lord. Other official, that word was deployed. I'm placing 29. Any person who is a president, secretary, or other official bearers of a registered cooperative society engaged in agriculture, industry, trade, banking.
29C, where are
2C?
I'm sorry, C19, my lords. 2C19, any person who is a president, secretary, or other office bearer. Other officers bearer includes the executives. So these particular provisions were incorporated in 2018 amendments.
Place that. Then, my lord. Receiving or having received any financial aid.
Yeah, that word Supreme Court is a sprinkle of acts. I'll just satisfy.
Are you governed by RBI rules or not?
But the RBI given license to
for banking.
Good enough.
Then you are in. That,
No, that judgment I have not gone through. Kindly, I will also give some judgment, my lord, where this case will completely cover.
Once a banking function, you have a banking function under the regulation of RBI, then irrespective of the fact that you are cooperative banks,
and my lord friend also examined part of the sprinkle of acts. Sporadically, some ads and all this. In this case, the executive officer can, the provision says that government officer can be appointed there. The provision is there.
And the management.
The bylaws of the bank you place down.
The management is the authority who will sanction the loan, not the chief executive.
That's a different point, sir.
All these things are tribal things.
These are all different.
Who is given, who is not given. All these things are factual.
Defense plea.
You have raised a valid legal dispute, and that he
we don't go to the ambit of the provisions of
the factual disputes are concerned, that will be sorted out in the trial only. I'm not going who has given the loan, how the application was moved, what has happened, and all these things are.
With the lordship permission, I'm giving the citation.
And what will be the impact once the money is recovered by selling the same collateral property?
Yes, my lord.
Which is alleged to have been a forged document.
My lord.
That was sold, validly sold,
yes,
and the money was given back. So, two consequences. One consequence is if it was an invalid document or invalid document, how it was sold. One thing.
Yes.
Second is once it is sold and the money is paid back, there is no loss to the bank. Whether still mens area is there or not.
My lord.
These are the two issues we have to again address.
My lord.
And
that judgment I will examine, my lord.
Okay, I'll put it next week.
My lord, next week, if the adjournment application will be filed, that will be.
I'm not saying anything.
I think
not with you.
In fact, Partha can manage it. Partha, you can manage to adjourn.
Manage. Next time, if you persuade me, then I will stay.
That delay underlying fresh admission also.
Delay can't on what?
And my learned friend also I will give the citation.
Yes, yes.
The citation is 2016, volume 3, SEC, page 788.
Volume 3,
SEC, page is 788.
Yeah,
CBI versus Ramesh Kelly. And my lord, I will give another judgment also, where the Supreme Court uses what sprinkle of acts. It may be sporadic.
Check all these things.
And you just verify another one. For me, a brief, at page 117, at page 102, you should place lots. That the chief executive, the post of chief executive shall be filled either by the direct recruitments or by deputation of a government officers. So there has been definitely sprinkle of ads to come within the scope and ambit of the definition of the public service.
Issue notice, at least on Thursday.
Visuals. Pursuant to the order of last
1 minute, sir, is waiting for.
With regards to item number 19, I am told
1 minute.
Mr. Das has made a mention that he will not be available.
Yes, you are telling me he is not well. So you tell me the
next week, on Friday or after 16.
Next week, as you. We will adjust and give a date.
My lord, sir. Next week.
Yes.
Trial court judgment I have filed.
You have another item 15, it seems.
15 by 498 case.
He will argue, and he is arguing very well.
Well,
he is now trained.
He was quite excited by it yesterday evening. I heard, yes.
Now he started arguing. Earlier he used to ask only adjournment. Now he started arguing.
He'll do it.
Let him do. Yes.
12 pursuant to the order of this Honorable Court and action, I have filed the judgment of the trial court and sought to the state.
But unfortunately, my lord, the copy is not.
He will cure the defects.
Yes. Trial court judgment flag A there.
Yes.
Copy there. Read. Judgment.
Copy total.
Oh, brief copy.
Copy will be not sir. No. Office instruction is there.
I will provide. I'll put a problem. Thela last occasion thela then
2012 this matter.
नहीं.
Sometimes you are not filing, sometimes he.
नहीं. Arthur thila could Mishra and provide a detailed copy. Arthur ka thila.
By the way, what is this case is about? Let us see first.
Please.
It is small matter, what?
दे दे बेटा दे.
325.
No, I'll provide.
Give the our copy.
मोड़ा कर दो.
We'll finish it up here now, just see. If it is small matter, why here? 2012 you have been, no? Let's see.
Charge as a payment 341, 294, 325,
You are
34.
convicted under
Only 325, 34.
Huh?
325, 34.
325,
34.
34. Sentence?
Sentence for undergo. So arrive for 2 years or 1,000 fine in default.
Yes.
Both the accused, one of the accused in the meantime have died. That is a Vijay Naik. So
He died.
there, the evidence of the only the victim lady has taken into account that he has attacked, pushed by the present accused persons with a stone causing some bleeding injury and has a in his eye.
Who has died? Munna Naik died?
Vijay died.
Now this is for Munna Naik.
Munna Naik.
He was 37 years.
Yes.
In the year 2012.
There are two eyewitnesses, my lord. Eyewitness schedule 4 and 5, and medical officer 2, medical officer schedule 1 and 7, my lord.
Injuries? Where?
Only injury in the near eye.
Temple.
A stone. The push and pull, he has fell down. That is a causing injury. But he has taken that he is pushed by a stone, through a stone in his eyes. Munna, there. It is the trial court evidence para 7. Munna was there and he also abused. Then the 325 has been dealt in para 9. The third charge against accused 325. IPC revealed that charge of 2012-2002 at 9 AM. The 2002 occurrence. The person in further concurrence of the common intention given hurt to the eyes of the Kasturi Naik. But it was not 3.
The injured, the post category that on the day of incident, the accused applicant, namely this mallet petitioner, who is alive, pushed a stone to her right eye, causing bleeding injury on her person. At that time, other accused applicant was holding her, leaving person nothing material contradiction or inconsistency was brought out from her mouth to raise any suspicion about the credibility. It appears from the circumstances of the case that at the time of assault by the accused applicant Munna, present to the injured, other accused applicants share the common object and a vicarious liability can be fixed on him for the act of the main applicant. The testimony of the injured having not shaken and contradicted the learned court below.
Eyewitness 4 and 5 supported.
And 2 doctors.
Injured witness deposed against you. Doctor is deposing against you. What else is there?
Here is that both are relatives to neighbors to each other. That there is no previous antecedent.
This is not a case of actor.
But here in the evidence 7, it is stated Munna was not there at the time.
How much you have undergone?
Undergone for 1.5 months because what I reported, but intimated, but I am not. The lower court judgment says the accused person arrested and were released on bail. 1 and some days there, but it is not reveals from record what is intimated by the trial court.
But have you not seen from the trial court record?
No, I will collect that from through pen drive.
You see from the trial court record how much you have undergone. I'll reduce to. I'll give you the benefit of POA and increase the fine.
That's it.
Fine amount and you have to pay that fine amount to the victim.
Yes, sir. Yes.
Right. Munna, the one of the land counsel for the petitioner submits that the petitioner number 1.
Two.
No. In the petition number 1.
Appellant 2.
Petitioner 2.
Appellant 2.
Vijay.
Oh, petitioner. Sorry, petitioner.
Petitioner number 2 has expired, so the present petition petition number 2 stands awaited. Stands awaited. Insofar as the petition number 1 is concerned, the matter was heard, and judgment is reserved. ଆପଣ already undergone ଦେଖି କହିବେ ବର୍ତ୍ତମାନ କହିବେ ଦେଖିକି ସେଠି ରହନ୍ତୁ ବସନ୍ତୁ ଦେଖିକି କହିଦଉ I'll increase the fine amount because he was 37 that time 2011 so now 37 means he must be around 37
12 वर्ष 12 added 14 around 50
is nearing 60 59 so it is sending him okay so fine increase you and the just see the undergone period date of arrest date of release in the trial court record you will get it immediately. Yes.
My lord, the petition of on the 24 to 22. That is the instruction.
Is on record. Let counsel for the state placed on record the instruction he received from
that is from the IAC.
From
the IAC
Baliguda PA. As per the instruction, the sole petitioner has expired on 24 to 2020. The division of the seat. Yes.
14, may I please, your lordship? I am on virtual mode, my lord.
Yes.
My lord, this is a conviction under section 379(34) of IPC and sentenced to undergo 2 years RI and to pay a fine of rupees 1,000.
Yes.
And which has been confirmed by learned ADJ Kalahandi, my lord.
Sorry?
Which has been confirmed by learned ADJ. Is the revision against conviction.
Confirmed, okay. I thought
yes, confirmed.
Yes, confirmed. And then you are ready. Then 2014, I'll put it in the weekly list. Get ready.
My lord, I am ready.
Yes, weekly list.
A small matter, my lord. Seizure has not been proved in this case.
Then yes, that's right. But you come to Monday and mention it, and we'll do it. Come here.
My lord.
Monday, he is ready. Monday, Tuesday, whenever you come, mention in the morning. I'll take it up. Okay.
My lord, I am ready, my lord.
Weekly. Yes.
Item 15, may I
Yes.
please, your lords?
Yes.
So the petitioner has preferred this criminal revision, preferring this criminal revision for challenging the order and order of conviction and sentence passed by Lawrence District Session Judge Nuapada Criminal Appeal number 11 of 2014, where he has partly allowed the appeal by modifying the sentence passed under section 498A of IPC and section 4 of DP Act. DP Act and sentence the petitioner undergo RI for 1 year and to pay a fine of rupees 3,000 in default to undergo RI for 6 months. And to pay a fine of rupees 2,000 in default to undergo RI for 3 months under section 4 of DP Act.
Your husband?
Your husband.
Yes.
Let's say the informant PW1 is PW11. The informant married to the accused in the year of 1999. As per caste, custom, and rituals, after 1 year, she was blessed a girl. Then accused demanded the color TV fees and a cash of rupees 20,000 at the time of marriage. And her father could not fulfill, and After her birth of her daughter, accused at the instance of his father demand color TV, fridge and 20,000 rupees from her father. When she expressed her inability, she was subjected to frequent mental and physical torture, and she was assaulted by a hand and other materials. After that, his son was born in the year 2002, but the torture was continuing. And on 1/7/2007, the accused and his father were in a drunken state asked her to bring above said articles, cash, and when she expressed her inability, she was assaulted by a burning firewood and she was locked inside a room. Next day morning,
When the FIR was registered?
FIR was 2007.
Date. There is a specific allegation in the her statement regarding an incident that is happened on 1/7/2007. When the FIR was registered. Whether in the FIR this incident is covered in.
Only PS case number 102 of 2007 was mentioned.
Date
is FIR copy is not there. FIR copy is not there.
To know the date, whether in the immediately in the month of July, 1st July, the incident has taken place.
Marriage was in 1999.
99.
Therefore, you have to see whether the FIR was registered immediately after the incident or what. See, and any villages examined?
Let's see with
Villages?
Yes, ma'am.
yes.
Villager is
Have you
PW
supported
5.
prosecution? Have you supported-
Co-villager of complainant.
have you supported prosecution?
PW 5 support. And other minors, some NGO members, PW 1
1
to
to
8.
8.
And it is
1
said
to
that
18.
some of the village meetings,
It was
and
conducted.
he has agreed in writing
Yes.
not to make any demand of writing. Those things
Yes.
are exhibited, writing.
And the NGO members 1 to 18, that was executed, madam. 3 by 1.
What happened to the divorce proceeding?
After the meeting was not successfully.
That you are reading para 9, I have seen it. Para 9 is there, you are reading in between and telling me. There, I am also there. I am asking whether what happened to the divorce proceeding initiated by her.
Let's say she did not agree to compromise the matter with the accused. Then she filed
Do
the
you have any idea about the divorce proceeding, whether they are still continuing wife and husband or divorce has been granted? What? I don't think you have prepared well. Monday. Monday you prepare and come.
Yes.
Properly. I have read it. Yes. Tuesday. I have read it. Yes. Next.
Let's
Please, Lord.
Lots from the last occasion, instruction was sought for from the Vigilance Council. If Lordship turn to page 12, Lords.
1 1, 2.
Page 12 of the petitioner's prayer notes. This revision is directed against an order rejecting his application under 457. 457, Lordship. And the ground is that medical examination and medical urology and all this. Lordship, turn to page 12, Lords.
Right.
The grievance is paid with 3 lakh rupees in an account number so and so, middle of the prayer portion.
Please, I have seen.
If my learned friend is ready for bank guarantees because of medical
Bank
grounds.
guarantee, where from bank guarantee for that same amount he should have no bank guarantee. Bank guarantee can't. Because he needs it for
medical treatment, Lord. No. Why say so, Lord? Because I was the counsel in this particular petitioner's case. You will also can turn to page 7. Page 7 of the Lordship brief notes. And my learned friend has very fairly revealed the other 2 cases also. In both the cases, I was the counsel, my lords. There, this Honorable Court directed that for release of the amounts, my lords. And now it's not that he is not in a state of penury, my lords. Not in a penury, but if he wants that money, some security, my lords, bank guarantees.
property.
Yes, sir.
Property.
Equivalent, subject to verification of the records.
Lordship may also note that it may be recovered if it is recovered from the ill-gotten money of the present.
I'm not going to say anything.
Yes, Lordship.
I will release that cash of 3 lakh rupees which is lying, subject to you furnishing a equivalent property security.
Yes, subject to verification of genuineness of those particular properties. And the property documents to be kept in the courts.
The petitioner has challenged the order being paid.
And I'm very happy, my lords, my learned friend, my lords, when I joined in his father's chamber, my lords, many years back, he come to me and calling, my lords. Now I have to cross with him, my lords. I'm very happy.
That's the beauty of this. Order dated 2/5/2024, passed by the Special Judge
Vigilance Summary.
In this case number 3 of 2023, filed in VGR case number 35 of 2017, whereby his application under section 457 CRPC for releasing of
rupees 3 lakhs.
Release of 3 lakhs.
Yes, sir.
Lying in the bank account number.
Page 12, Lords. Page 12. Prayer.
Lying in the bank account number, so and so.
36185.
He will take it out.
On the prayer portion.
Page for prayer has been turned down. Mr. Das, Legal Counsel for the Vigilance, submits that the trial court has rightly rejected the application for 457 CRPC, and no interference is called for in the facts of the present case. However, on the contrary, Avas Mantil and Counsel for the petitioner submits that he died in need of the cash
for the medical
agency in the family.
Of the present petitioner number 1.
For the petitioner.
Petitioner number 1.
Who is suffering from
cardiological urology since 2020.
Since he has been suffering from cardio and
Urology.
problem, cardio and neuro problem.
Urology.
Taking into consideration the facts of the present case, I am inclined to allow this petition with the direction to the vigilance respondent vigilance department to release to pass on appropriate instruction to the State Bank of India Sundargarh to release the said amount of 3 lakhs lying deposited in the bank account number so and so, subject to the condition that the petitioner furnish equivalent property security. The Learned Trial Court
to ensure
should check the genuinity of the document and property security, and after retaining the original document, the appropriate order maybe shall be issued so as to release the cash lying deposited in the account. With this
Lordship may stipulated time period, Lordship.
the entire process may be completed within 15 days. Depending upon you have to give the.
Yes, sir.
Lordship may indicate as expedient as possible. I will also talk to
As
the
expeditiously as possible.
Can't say जो registering authority को contact करिवे जो contact करते sub register contact
Sub register because समस्त को verify करिए पड़ेगा.
Anyway, sir, thank you.
Oh, the trial court will do well. Don't worry. The trial court have larger experience with it. Yes, sir.
Obliged, sir.
Allowed, huh?
80 matter is ready for hearing. Maybe
Yes, ma'am.
tagged in the weekly list.
I filed the Bhoklat now, my lord. My name does not reflect in the cost list, my lord. Already filed. My lord.
P.K. Mishra's name maybe reflect in the cost list as well as for following for the government on behalf of the petitioner. Matter is ready for hearing.
Let it be Tuesday.
Weekly.
Next Tuesday, my lord.
It will be there in the weekly.
I'm also ready. I'm also ready. Yes, ma'am.
Give prior notice to Mr. Rizvi so that he, in the same time, he will also prepare.
Yes.
And mention me, I'll take it up.
Okay. Yes,
and 2 o'clock, after 2 o'clock, I'm searching people who can come and argue. You prepare and tell him that he should also go and argue.
Yes, my lord.
Who stops you? And this is an appeal of 2012.
2012, my lord.
Take it
2012.
up.
Yes.
But give prior intimation because
Yes,
he has to also prepare.
On Monday, I will intimate it to him.
Whenever you are ready,
Ma'am.
before one day if you give notice,
Yes,
at least he'll get ready.
I am obliged.
Because if next day if he is lined up couple of matters,
Yes.
he may not get ready. So
Ma'am.
next day you can.
I am grateful.
That way. Okay.
Obliged.
Yes.
Can you start talking about So silent.
अगर impression आज होती meeting है वो what is it?
Yes, call. Let us see. Quickly. Let us see if something can be disposed of or. Yes. Huh? Call wherever you are supposed to call. Where from? Mr. Rijvi is not there. Revision कर रखो ना. देखियो आप यदि किसी छोटा मोटा अचीव कर रहा.
78 checks.
70?
79.
79. Yes, 79. 2012 matter.
It's not.
What is this matter? Let's see.
That's the 2012.
457. 304506. Huh? 70?
75.
Come 75 will be. Yes. Yes. No, 75 is there. You want to do then at least one matter we can finish up. Yes.
Yes, 75.
Convicted under section 406 of IPC for
Yes.
6 months. And the appeal was confirmed for the same matter. And period undergone my lord, only 11 days he remained custody during trial.
11 days.
My lord.
Sentence is?
My lord.
Sentence?
Sentence 6 months, my lord, 406. Charge was pressed under section 401, 467, 468, 477 of IPC, and thereafter he was convicted under section 406 of IPC. Since there was no offense was made out under section 401, 466, 470.
He was 51 years old in the year 2002.
My lord.
51. So now about
At the time of filing of the appeal, my lord, he was at
58, my lord.
58 years.
58 years.
That is in the year
2012.
12. Now he must be 58 plus.
My lord.
7.
Huh?
7.
70.
70.
70. 72.
72.
My lord.
Yes. So what do you say?
My lord, 6 month conviction, my lord. And yeah, at the time of
406, na?
406, my lord.
What is minimum?
My lord.
Minimum.
Minimum sentence is 3 years.
Minimum.
3 years.
406.
What the meaning?
With implement either decision for a term which extend to 3 years or
Or fine or may extend.
May extend.
What was the fine amount?
My lord.
Fine amount?
No, fine amount is
Ah.
not.
Get the fine.
देखा था उनका फल एक पूरा क्लियरली लागून.
No fine.
no fine.
No fine, my lord.
No fine. Sentence for 6 months. That's the period undergone by the convict as UTB be set up.
11 days.
6 months.
11. 19/9/2022 he was forwarded and he was released on bail 30th 9 2020 2002.
What about in the appeal period? No.
No, my lord. On the same day he was released on bail during appeal. 6 month conviction up to 3 years usually granted bail, my lord.
18 and 2 benefited.
My lord. And as per 406 the evidence, my lord, he has a temporary misappropriation. In the meantime he has paid the amount also, my lord, during investigation.
He's paid the amount.
Yes, my lord.
75,000.
75,000.
Where is that so?
କୋଉଟା କହିଲେ? ନାଇଁ ନାଇଁ ଯୋଉଟା ଥିଲା ଏଠି ଦେଖ.
Where is that? Show me. Where have you paid?
The point formulated, the point about determination of the are follows, my lord. There are 4 points, my lord, for determination, my lord. The point, whether the accused forged the GPA voucher relating to the Khadia Naik on 25th 7th 2004 to receive a cash of 75,000.
No, received for the temporary period he has used.
Temporary. He was in charge, my lord. Payment he on 2 occasions.
No, that's right. Offense is made out. I'm not on that. But money is paid. Obviously.
Money is paid, but no intention is there and motive is not there to cheat, my lord. He was the in charge officer. He has not.
No. For how much period you have used that 75,000? Period you tell me. I want to evolve a formula. Suppose he used for 1 year, whatever. 18% interest, whatever is that will be the fine. Which period to which period?
Clearly.
Which period to which period?
Yeah. Paperwork is not visible, my lord.
It's all right. Which period to which period? Roughly you would give. In so far as sentence is concerned, that will be undergone. I'm trying to find out what will be the fine.
Yes, ma'am. Page 2, internal page 2, my lord, of the judgment, my lord.
You tell me what period.
It is stated that the prosecution case of the informant Khadia Naik is serving as sweeper in the office of the Homeguard Pulwani in the month of June 2002. He had applied for GPF of voucher 1 lakh. Account R. Tarini Charan Reddy and Pion Narjan Pradhan had also applied for GPF advance along with the informant. After calculation of accused, disclosed the informant that he has entitled to a sum of rupees 75,000 as GPF advance. The accused Nazar Harijan received their GP advance, but intent did not show the report that not clearly visible one.
Hey, what is the allegation?
Yes, ma'am. I am coming to that. GP amount of 75,000 in the name of accused. The informant in not put his signature on the relevant not visible, my lord. Which is this statement? The accused is received the said amount and deposited in his book and also assured to repay the amount. Informant accordingly on
what is the allegation? You tell me.
Allegation is that, my lord, he has the informant applied for GPF, my lord, for about 1 lakh rupees and GPF was sanctioned 75,000. Instead of sanctioning the GPF amount, my lord, the present appellant petitioner, he has deposited in his own account, my lord.
That he took the GPF amount and deposited it in his
own account.
And when he complained, he gave it back.
Yes, ma'am.
That's the key.
My lord.
It is the list in this.
On 3/9/2002, they accused a sum of 50,000 and 499.
Page 7, my lord. Point number I, my lord. Page 7 of the trial court judgment. It is alleged that the prosecution that the accused being in charge of account section received cash of 75,000, which was released as GPF advance in favor of Khadia Naik. The informant is examined as P 6 in his evidence. He reported that he had applied for GPF withdrawal and a sum of 75,000 was sanctioned by the authority. P 6 further report that he did not receive the said amount for which the orally reported the to the DSP.
That's what he says.
Then my lord, for convenience, my lord, it is further transferred from the evidence. P 6 the DSP called the accused inquiry about the non-payment for GPF amount and the accused disclosed that he had kept his GPF advance in the bank. He further transferred from the evidence 6 to that the DSP directed the accused to pay the same to the informant immediately. At paragraph 3 of his evidence, Schedule 6 also report that on 13/9/2002, he, in presence of the DSP, the accused paid him a cash of 50,000.
PW6 is the informant.
Madam.
Madam.
And 14/9/2002, 25,000. This is correct.
Right, no, write down. PW6 is the informant in the case. He inter alia alleged that he had applied for GPF of rupees 1 lakh. The department has sanctioned only 75,000 rupees. 75,000 rupees, which was not disbursed to him. Rather, the same amount was kept in the bank account of the present accused, who was working as
Sweeper, my lord.
Yes,
ma'am.
Being in charge of account section.
Present accused
Being the in charge of
account section has retained the amount and used the same for his own advantage. Subsequently, when the matter was reported to the police, the present accused on
my lord, 13/9/2002.
13/9/2002.
In presence of DSP, he paid cash 50,000.
Right now, same thing.
And on 14/9/2002,
DSP, he paid rupees
50,000.
No, first account.
13/9/2002, in presence of DSP, the accused paid him a cash of rupees 50,000. That is evidence in
15,000.
50,000.
50,000, yes.
And on 14/9/2002, he had paid a rest of amount of rupees 25,000 in presence of DSP.
Yes. In presence of DSP. Therefore, the
evidence of 6
Therefore, Mr. Mishra contends that he has his client has already paid 75,000 rupees, which are withheld by him and used for his own advantage. In that view of the matter, there is no loss to the informant. Yes. I am not writing the judgment. I am just.
It is admitted by the accused that he, being the in charge of the account section, but the accused examiner did not do it. Still better manner.
Accused examined himself as a DW2 and admitted.
Admitted that the accused that he, being the in charge of account of Home Guard office, Fulbani, received 75 lakhs GPF advance to informant, and same was duly disbursed to the informant on the same day.
Okay.
Paragraph 10 and floor court judgment.
Admitted that what you say?
Admitted by the. It is admitted by the accused that he, being the in charge of account of Home Guard office, Fulbani, received 75,000 of GPF advance of the informant, and the same was duly disbursed to the informant on the same day.
Okay. Taking into account the aforementioned facts, peculiar facts of the present case, I am of the considered view that the sentence imposed, a sentence awarded to the petitioner is liable to be modified accordingly. And accordingly, the substantive sentence of 2 months, 2 months.
6 months.
6 months. 6 months. RI or SI?
SI.
SI is reduced to that of the sentence. Petitioner has already undergone. Petitioner has already gone. The petitioner is also liable to pay a fine of rupees 10,000. Fine of rupees 10,000. 10,000 in default to further undergo a period of 15 days. 15 days. 15 days. SI. 15 days. I will put it to Mr. Mishra, learned counsel for the petitioner submit that the petitioner was taken into custody on
19/9/2002, my lord. He was forwarded.
19/9/2002.
And he was released on bail on 30/9/2002.
30/9/2002. Therefore, he has undergone a custody period of about 11 days.
My lord.
11 days in total. Keeping in view the fact that the petitioner was 58 years at the time of filing the petition in the year 2012, and the fact that the incident had taken place way back in the year 2002 or 2002, and the misappropriated amount has already been paid back by the petitioner
on two installment.
to the informant.
Yes, ma'am.
The petitioner deserves a lenient view insofar as the sentence is concerned, accordingly the following sentence. Okay.
Sorry, my lord, 6 month RI, my lord, instead of SI.
I will check it up. Just the draft, put it draft print out करके उसमें साथ में लगा देना.
This is the profile matter. Still written by file can be taken.
What is that?
90 days.
Big give it to me.
Delay रखिबो. Delay थोड़ी ना, मुझे तो फाइल करनी है.
This is I think limitation. Not you thought it period undergone. It's limitation. इसका प्रिंट आउट निकाल साथ रखना जजमेंट. ठीक है. अगला
77.
Yes sir. Yes madam. Yes sir. I whoever is ready argue.
7 the petition challenging the order that confirm the
Give the file to
there is no instruction.
no instruction.
Challenge the order that 14/8/2007 offense under section 27(1)(a), 27(1)(b), 27(3)(c) Orissa Forest Act convict and sentence the petitioner to undergo 1 month imprisonment of 27(1)(a), another 1 month, under 27(1)(b) and 5 months imprisonment, 5 months.
Total is 5 months.
5 months.
Concurrent. Yes.
And the fact is like this, on 2/8/2000.
How much you have undergone?
Hello.
How much you have undergone?
As per the verified order, before the London court below 22/6/2005 रे ଯାଇଥିଲେ custody and release. 22/6/2005. 22/6/2005 रे before the London court below. 22/6/2005. Another
22/6/2005 ହେଲେ ତାପରେ ବାହାରିଲେ କେବେ?
ସେବେ ରିଲିଜ ହେଲେ ବୋଲି ଯାହା ମୋ ପାଖେ ସେମ୍ ଡେ ହେଇଥିଲା. ଆଉ ଗୋଟେ 4/9 କଷ୍ଟଡି ଗଲେ, 7/9 ବେଲ୍ ହେଲେ ବିଫୋର ଦ ଆପିଲେଟ୍ କୋର୍ଟ. ସେମ୍ fact is also due to patrolling the
Paragraph 6. In the evidence we told to forest guards before that 2/8/2000 at about 11 to 11 a.m. 10 to 11 a.m. while he along with the Lakshmanadas forest guard had been to North
Dhani
Reserve Forest a patrolling duty. On patrolling found that the accused persons already cleared 2 acres of forest land for their
agriculture purpose.
During their duty, they seized 25 bundles of half-burnt bushes and called the accused person.
The poor people,
man.
They don't have land, they want to
For that,
but take 1 minute. Take custody period, let us see. When the date when you checked?
ଆଜ୍ଞା ମୁଁ ଯାହା ଡେଟ୍ଟା ଟିପିଛି 22/6/2005 ରେ ଆଜ୍ଞା ଟିପିଛି ଗୋଟେ ମୁଁ ସେ ବିଫୋର ଦ ଲର୍ଣ୍ଣିଂ କୋର୍ଟ ବିଲ ଆଜ୍ଞା
22/6/2005
ଆଜ୍ଞା ଲର୍ଣ୍ଣିଂ JMFC ଅର୍ଡର ରଣପୁର. ଏଥିରେ ଜୟଦେବ ରାଣା and ରବି ପରିଡ଼ା ବେଲ୍ ଆଉଟ୍.
No, 7/9/2007.
ଆଜ୍ଞା ଏଇଟା 4/9 ପର୍ଯ୍ୟନ୍ତ 7/9/2007 ରେ ଆଜ୍ଞା ଆପିଲେଟ୍ କୋର୍ଟ ବିଫୋର ଦ ଲର୍ଣ୍ଣିଂ ସେସନ୍ ଜଜ୍
Appellate court.
ଆଜ୍ଞା
Appellate court.
ନୟାଗଡ଼. In criminal appeal.
He was 7/9/2007. He was granted bail.
ଆଜ୍ଞା criminal appeal number 20.
1 minute. When you got the conviction order? When you were convicted?
Convicted of 4/9
16/11.
କିଛି ପଢିଛନ୍ତି ନା ନାହିଁ? ବୁଝନ୍ତୁ, we will try. for you. Don't interject in between.
Trial court judgment agreement.
4/9/2007 arrested.
JMFC signed my lord 14/8/2007.
14/8.
14/8/2007. Judgment.
Thereafter, he was taken into custody. 14/8. 1 minute. 14/8/2000.
Judgment, date of judgment.
14/8/2007. And he was granted bail on 7/9/2007. Why are you saying 4/9? He was taken into custody. He was taken into custody and the day judgment was pronounced or subsequently?
Yeah, bail my lord. The court my lord violated. Convicted them, the court must not my lord release them on bail and they are asking him to obtain the bail order from the appellate court my lord. That is the
Because he was never in custody then.
never. That's it. Date of arrest is the
Not undergone at all.
In fact, they have cleaned to a.
Clearing the forest land for agricultural purpose.
Chalo, Yes. दे दिया yes any matter if you want to
there is a plea against the order of confiscation. I have been asked to furnish a bank guarantee which I have furnished and I have kept on renewing it. In the meantime, I have been allowed to protect my property. But the main person who was facing the prosecution died in the meantime. So the appeal abates. But under section 19 of the Special Court Act, we can file a petition before the authorized officer seeking return of the property. So I'll do that. Let the interim order protecting my property on the basis of bank guarantee continue till they decide the issue, my lord.
Which item?
The item ta ko?
144.
144.
Sir.
There is an interim order. Let it continue. He will go and move application and that will be decided.
Bank guarantee of 10 lakhs have been furnished.
Bank guarantee. After all, it is bank guarantee.
May I suggest, my lord, did it come Monday, my lord, so the same.
Let us see. If it is not a prejudicial order, why to wait? Let us see. Let us. Item number?
Sir, 144. Sorry, sir, file at
144.
Sir.
Give 144 file.
Extreme.
Small matter unnecessary. There is no point.
My lord, your lordship may see that order 18/5/2012.
Take my file.
18/5/2012.
Give him our file.
Sorry, sir.
No,
Sorry,
it's
sir.
all right. No problem. And please see that thereafter.
He died. In the meantime, he died.
144, na?
Sir.
144. Surya Narayan Behra.
Sir, sir, sir.
Yes, sir. Then 2012 it is pending for no reason.
18/5. It is at the bank guarantee.
See that.
Who has died? The main accused.
Sir.
Who has died? Surya Narayan Behra.
Surya Narayan Patra died. And this is the order, your lordship may peruse this order, my lord.
I order dated?
18/5/2012.
18/5. Give it to him. But
He doesn't want to see it.
My lords, your lordship may take it on Monday, my lords. Mr. Simon Das will do it in all special court matters, my lords. I have not applied the minds, my lord. That's what.
Monday supplementary.
I'm withdrawing the case.
Monday
In any
supplementary.
case.
Since you have,
Sir, aso, sir, Monday. Mu sir, asi kori.
Monday.
At 2 PM better.
No. Monday at the item number 1 in weekly. Item number 1
Sir.
weekly. You come in the first morning.
Sir, I'll come, sir.
And he's not asking a very prejudicial order. He's asking if the interim order which is there, should continue, he move application till then it will continue. How to? Since 2012 it is going on. It will continue for another
And I have
2-3 months.
I have kept on renewing the bank guarantee also. Madam.
Bank guarantee, yes. We'll do that. Okay. Item 1. Monday, item 1. Okay. Yes.
Item 147, my lord. There is
147.
a noting that one LCR has not received, my lord. Can it be a direction for a
147.
reminder? Yes, my lord.
It is received. 147.
Not received. No, my lord.
147.
Yes, my lord. Vigilance.
No, TCR is there.
TCR is not there, my lord.
नहीं है ना भाई, इसमें तो है।
नहीं vigilance.
नोटिंग तो छोड़ो, यहाँ तो एशियर पूरा है। If this is the case, 147 is Prasant Chandra Naik.
Yes, my lord.
TCR is there.
But noting is that my lord.
Not received. Wrong noting is there.
Wrong noting, yeah. It is there.
It is there. Yes, my lord. Then it's okay.
It is,
Obvious.
you want to inspect, it is there.
Yes.
So wait.
No, noting is that my lord, TCR is not received.
Same case, TCR is there.
Yes, ma'am. But there is a wrong noting. Is
wrong noting.
Yes, ma'am.
Now, if you want to inspect and ready.
Yes, ma'am. Next week, ma'am.
It will remain.
Yes, ma'am.
Whenever you are ready, you come and argue.
Ma'am.
I'm waiting after 2 o'clock. Whoever comes, and I will.
Yes,
no problem. Irrespective of wherever the number is here. Anybody?
Okay.
Are you interested to argue any matter? Nobody is there. You have any matter with your name? Urgent. Okay, thank you.